Welcome to one of the most unpredictable courtroom moments you'll ever see. The case of the People versus Antoine Patterson takes a shocking turn before it even begins. A domestic violence plea hearing, already a serious and tense proceeding, is immediately thrown off balance when Patterson apologizes to the judge for not wearing pants. What starts with laughter and disbelief quickly spirals into a high-stakes battle over whether his guilty plea can even be accepted.
In a tense court session, Antoine Patterson attempts to plead guilty in a domestic violence case. However, Judge Elaine Washington raises concerns about Patterson's understanding of the charges and the intent behind his action. After some hesitation and a discussion about the details of the plea, the judge decides to adjourn the hearing for further legal counsel, delaying the decision. Watch as Patterson's fate hangs in the balance and the case takes an unexpected turn.
Court calls the case of the People versus Antoine Patterson.
Good afternoon,
Ready, Judge. Portia, please come on behalf of Mr. Patterson. Opposed? Please state your name for the record, sir.
Antoine Patterson.
He
Senior.
apologizes for not having on pants. Mr. Bellinger did not tell him he had to wear pants. So.
Oh yes. Oh my God. Oh my God. And it's laundry day. I promise. Like I missed when I was supposed to go to Hope Clinic, and I had missed that when it was like 98 outside, and I was supposed to go to Hope Clinic yesterday. Well, I don't remember the day, but we rescheduled it for Monday, and I got like 4 big bags of clothes, and I actually wore these already, and I don't even got my right belt. Like
He
he
apologizes, Judge, for not having on pants.
To the deepest of depths of my apology. I apologize. Sorry.
The courtroom is stunned as Patterson nervously explains why he showed up without pants, blaming laundry day and even cracking a joke about his colorful socks. The defense attorney tries to move things forward, but the tension is clear. This isn't the image of a defendant ready to enter a serious guilty plea. And here's the problem. Judges need confidence that a defendant understands their choices.
There's a lot more information I need.
He does have colorful socks, Judge.
What?
He does have nice, colorful socks, though.
You fix those out on purpose. No, I'm kidding.
So
I get it.
the court should have 2 things in the file, Your Honor. If the court's willing to do a plea, we have a plea and advice of rights in the form. If it arrives too late, we also have a green sheet for an adjournment, Your Honor. So whatever the court's pleasure.
Why would you be too late in the form?
Okay.
It's not going to be a no contest plea.
No, Judge. All right.
So it'd be pleading, what the plea form indicates is that it's pleading guilty to domestic violence.
Yes.
That being count 2. Count 1, the child abuse, 3rd would be dismissed. There is, the defendant is agreeing, and actually also prosecutor and defendant. Yeah. So it's actually checked both 3 and 4 that they're agreeing to 7694A, 2 years probation. The offer is contingent on the defendant having no assaultive contact with the minor victim or anyone else since the incident date for the case. Defendant not to have contact with any minor children other than his biological children. Oh, so that's the CPS recommendation. The only part of this that I want to make sure the court's understanding is that I read that to mean that if there is a accusation that comes up that is not known at this point.
Slight amount of detail, Your Honor. So there has been allegations, and I know both sides have tried very, very diligently to figure out what those are specifically, and you're just not getting enough information. So in the interest of moving this forward, we've adjourned quite a few times. It's contingent on if I receive information or anyone receives information that the victim has been harmed in any way by the defendant since the incident that underlies this case, then that changes everything. We would withdraw the offer, and of course, you know, the plea would then be void essentially, and we'd be back here.
That you're understanding.
That is what Mr. Bellinger negotiated. Yes, Judge.
Wow. Okay. I have him to one.
Right hand. Do you solemnly swear and affirm the testimony about to give the true self you got?
Yes.
State your name.
Antoine Patterson Sr.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of domestic violence. Is that correct?
Yes, sir.
That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. You understand that?
Yes.
All right. You understand also, sir. Why are they forgetting this?
Oh, this check.
I just checked.
Oh.
And I want to make sure he understands.
Oh, okay. Yes, Judge. So he won't be here. He just was Washington.
So you understand that while I'm taking your plea, I would not be your sentencing judge in this matter. You understand that, sir?
Yes, sir.
That you would be sentenced before Judge Washington.
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Is it okay to ask a question?
Here Patterson's real concerns surface. He wants to know if probation means the charge will eventually disappear from his record. This moment exposes the delicate balance of plea deals. On paper, the offer is 2 years of probation, no contact with minors, and the dismissal of a child abuse charge, far lighter than possible jail time. But Patterson seems more focused on how this will affect his future than on admitting guilt.
Sure.
Okay, so when you say sentencing and I get to the sentencing court date, the 2-year probation thing and the 4A, that's when I do my probation and I'm off, like just I don't have to try to get it expunged, correct?
Well, I think what he's asking is if he successfully completes his probation
When that's
under 4A, will this be removed from his record per the statute?
And the probation is what I'm going under. So when I get to the sentencing, he's just going to sentence is it like for a short 2 years probation or can it be up to 2 years?
The way I read this plea agreement is that you're agreeing to 2 years probation.
Okay, yeah, that's fine with me.
Okay.
Just wanted to clear the BS. I
Okay.
still want to plead guilty.
You still want to plead guilty?
Yes, sir.
All right. You have any other questions?
No, sir.
All right. To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form.
Yes,
Is that correct?
I believe so.
Any
Yeah.
question regarding those rights?
No, sir.
Look at paragraph 5. Those are your rights which are a part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
All right. On the date, did you wish to voir dire or you want me to write?
I will prefer you to, Your Honor.
Okay, no, that's fine. That's fine. I just didn't know in terms of specifics. On July 8th, 2000, between the dates of July 8th, 2024 and July 9th, 2024, at the location of 2871 Binding Drive, apartment 308 in Ypsilanti Township, Washtenaw County, state of Michigan. What did you do that makes you think that you're guilty of this offense?
I had a lapse of emotions and made an erratic decision on impulse of high concern.
And what did you do?
I hit a kid and I hit him. I gave him what I feel was a whooping.
Was this child in your household?
Yes, sir.
All right. And so that you had that relationship with the child that you lived together.
Yes.
All right. And
Now we reach the turning point. Patterson admits he struck a child in his household, but stumbles when asked whether he acted intentionally. His words shift between pretty much yes and uncertainty, creating a dangerous gray area. The judge's job isn't just to rubber stamp a plea, it's to ensure the facts support the conviction. In criminal law, intent is everything. Without clear acknowledgement that he knowingly committed domestic violence, the plea collapses.
I'm a little bit concerned as to you intentionally did the acts to this child that, as you say, constitute a whooping.
I'm sorry, say that again, please.
The acts that you did intentionally.
Intentionally, no, I don't want to say like I didn't intend to. You know what I'm saying?
Okay.
Can I help
I'll stop you right there? Because go ahead.
Thank you. What Judge is asking you, I think you had a conversation with Mr. Bellinger before he left, was you had a relationship with this child that lived in the home with you.
Mm-hmm.
And that's a yes?
Yes.
Okay. And you proceeded to hit that child.
Yes.
And you knew what you were doing.
Well, yeah, I mean, pretty much yes. So yes.
Well, pretty much yes, or
yes.
So you knew what you were doing, and you whooped that child, correct?
Yes.
And that could be considered by some, the court, the prosecutor, an excess of what was appropriate.
Yes.
That's a yes?
Yes.
If the court wants to adjourn for Mr. Bellinger to have more conversations?
I think I'm going to. I'm not going to accept his plea. I'm a little bit concerned.
Okay.
Based upon
May I
what
more
you said. Pardon?
I'm sorry. I spoke out of turn.
No, go ahead.
Okay, so this has been going on for a while. I'm trying to get the sentence under it because when I went to Michigan Works to try to get into the electrician.
Okay,
Hold on.
listen to me, sir. The problem is, and I understand you may be wanting to move this along, the prosecutor wants to move, everybody wants to move it along. The difficulty is for me is I have to be assured and convinced that you're voluntarily pleading on this, number one, and that what you are telling me you did would constitute this crime.
Okay.
All right. Because of the way that you answered some of the questions. I'm not saying it's answered wrong. I'm just saying these are my concerns. Because of the way that you answered the questions, also because of some of the things and hesitation that you had in response to questions, I have some concerns as to whether or not you believe that you may be guilty of this offense. And so for your protection, as well as the protection of the plea and the integrity of the plea, I'm going to adjourn this.
And just like that, Judge Ira Washington halts the entire proceeding. Refusing to accept Patterson's guilty plea, she adjourns the case and sends him back to consult with his attorney. What was supposed to be a routine plea deal ends in uncertainty, with Patterson's fate postponed and his credibility questioned. This case highlights a vital lesson. In court, clarity is everything. A guilty plea isn't just paperwork. It's a binding admission with lifelong consequences.
Not going to accept your plea today. I'm going to adjourn this out and allow you to speak with counsel.
Okay.
Some additional time. All right.
All right. Thank you, sir. I appreciate it.
And what I will do then is I will adjourn this to the 17th.
Thank you, Judge.